What's the standard for granting a motion for summary judgment in federal court?
Thank you for the question, Senator. Summary judgment motions in federal court are evaluated under Federal Rule of Civil Procedure 56. The question is whether there is a genuine issue of material fact that will require a trial. The moving party has the burden of proof of establishing that there is no genuine issue of material fact and that judgment should be granted as a matter of law. If the moving party does not meet that burden, then summary judgment is denied and the case goes forward to trial.
Okay. So basically it's just, are the facts in dispute and is law in your favor?
What you just watched is exactly why Senator John Kennedy has become one of the most watched voices in Senate hearings today. This was not noise or political theater. It was precision. In this clip, John Kennedy does what too many lawmakers avoid. He slows the room down, asks simple but important questions, and reveals whether judicial nominees truly understand the law they want the power to interpret. What stood out to me most was not aggression. It was clarity. Calm, focused, and relentless clarity. Some people call that intimidation. I see it as accountability. If you care about who ends up on the federal bench and whether they are prepared, informed, and independent, this hearing matters. You are watching Congress Lens. I am Audrey. If you want sharp, no-fluff reactions to what really happens in Congress, like the video, subscribe to the channel, and let's get into it.
Judge Gaston, on December 6th, 2008, you talked about this with Senator Graham. I'm going to quote, children are not safer because registered sex offenders are prohibited from residing near schools, parks, daycare centers, and other places where children tend to gather. End quote. Did you write that?
I co-wrote that article, yes, sir.
Okay. When you wrote it, did you believe it?
I did.
Okay. All right, let's start back down on this end. Ms. Al-Madani, tell me about this doctrine of qualified immunity that we're discussing here in Congress and in the newspapers.
Thank you, Senator Kennedy. Qualified immunity applies in 1983 cases as well as Bivens actions to law enforcement officers.
Right.
Unless there is a clearly established constitutional violation, they are subject to qualified immunity. They are immune.
Okay, thank you for that. Let's go to Judge Hunt. Judge, what is the standard? I'm sorry, I keep bumping my mic. What's the standard for granting a motion for summary judgment in federal court?
Thank you for the question, Senator. Summary judgment motions in federal court are evaluated under Federal Rule of Civil Procedure 56. The question is whether there is a genuine issue of material fact that will require a trial. The moving party has the burden of proof of establishing that there is no genuine issue of material fact and that judgment should be granted as a matter of law. If the moving party does not meet that burden, then summary judgment is denied and the case goes forward to trial.
Okay. So basically it's just, are the facts in dispute and is law in your favor?
That's probably a shorthand for it, but really it's, are there material facts in dispute? Because in my experience, there are often factual disputes, but the question is whether they are material to the resolution of the issue.
Otherwise you wouldn't be in court.
Exactly.
Judge Hugh, tell me about New York Times v. Sullivan.
I believe that was a First Amendment case, Your Honor. I'm sorry, Senator, about free speech. But in my 5 years of being a judge and 25 years of practice, I haven't had to actually apply New York Times v. Sullivan.
Okay. Judge, well, I talked to Judge Yasin. Judge Cummings?
Good afternoon, sir.
Good afternoon to you, sir. Tell me the rule that the United States Supreme Court follows in deciding whether to overturn precedent.
Thank you for that question, Senator.
You're welcome.
In deciding to overturn precedent, the court looks at a number of factors, including the soundness of the reasoning of the decision in question, the workability of the rule that it establishes in terms of how it is applied, developments that have taken place since the decision was issued, and they also look at reliance that parties or litigants have placed upon that decision in question.
Okay. Let me ask you, well, I'll start back here again. What did the White House give you to prepare for today's hearing?
Senator, there were a number of meetings with the White House counsel's office.
Did they give you any written materials to read?
There were some written materials.
Tell me, what were those?
There were materials that were already in the record, questions and answers from prior hearings.
So they gave you a list of questions and answers from prior hearings?
An overview, I would say.
Yeah. How many questions and answers did they give you?
I'm not sure, Senator. Sitting here, I'm not sure exactly how many questions.
Was it more than 10?
Yes.
More than 50?
I don't believe so.
Okay. And whose questions were they?
They were Senator's questions.
Which ones?
There were some of your questions, Senator.
Were there?
But I also watched many hearings, and so I'm.
Thank you, Mr. Chairman.
That's a tribute to you, Senator.
I'm smiling.
After watching the full hearing, one thing is very clear to me. Senator John Kennedy came prepared, not with talking points, but with purpose. Let's start with the exchange involving Judge Gaston and the 2008 article on sex offender residency laws. This was not a trap. Kennedy asked two straightforward questions. Did you write it and did you believe it when you wrote it? Judge Gaston answered yes to both. That matters because Kennedy was not speculating. He was holding the nominee to his own public record. Then we get into qualified immunity. When John Kennedy asked Ms. Al-Madani to explain the doctrine, he was doing something viewers rarely see. He was checking whether a nominee could clearly explain a legal protection that directly affects both law enforcement and ordinary citizens. She gave a solid definition. Kennedy acknowledged it and moved on. No hostility, just evaluation. The same approach shows up with Judge Hunt during the discussion on summary judgment. Kennedy simplified the issue, asking whether it really comes down to disputed facts and the law. Judge Hunt clarified that only material facts matter. This exchange shows something important. Kennedy respects expertise, but he insists on clarity. If a judge cannot explain the standard in plain language, that is a red flag. One of the most telling moments comes with the discussion of New York Times versus Sullivan. This is foundational First Amendment law. When a nominee admits they have never actually applied it in decades of legal practice and years on the bench, that should concern anyone paying attention. Kennedy does not attack. He lets the answer speak for itself. Then comes the moment that gives this video its title. John Kennedy asks a simple but powerful question. What did the White House give you to prepare for today's hearing? That question goes straight to judicial independence. When the nominee confirms meetings with the White House counsel's office and admits receiving written materials, including questions and answers from prior hearings, the tone shifts. Kennedy calmly follows up. How many questions? Whose questions? And when it becomes clear that some of those questions came from John Kennedy himself, the irony is impossible to miss. This is why Kennedy's style works. He does not accuse. He documents. He does not rant. He listens. People can disagree with his politics, but it is hard to argue with this approach. Judicial nominees are not applying for a short-term job. These are lifetime appointments. If nominees are coached, rehearsed, or shielded from scrutiny, the Senate has failed its responsibility. John Kennedy did not fail here. He reminded everyone watching that these hearings are not formalities. They are tests. And simply showing up is not the same as being ready. That's my take. Let me know yours in the comments.